efforts on clarity of methodologies on the adoption of data protection regulations to ensure compliance, and also the need to provide assistance to SMEs to learn how to mitigate risks associated with compliance with data protection rules, knowing fully well that SMEs are also critical stakeholders in this. And then we went straight to the keynote presentation, and that was done by Dr. Olalade Shilon. She introduced the audience to what actually do we mean by privacy, so definitionally. She took us through some theoretical underpinnings as it relates to data protection, and the basic principles governing data processing as vis-a-vis consistency and legitimacy, lawfulness and fairness, purpose, relevance and storage, accuracy, transparency, confidentiality, and security. She concluded our presentation by making some recommendations, part of which, number one, is that as a country, we do not need to reinvent the wheel, but rather we could borrow from most recent legal frameworks on data protection. She also recommended the need to take into account domestic laws, the Constitution, the existing Federal Freedom of Information Act, and other relevant laws. She concluded by advising that we should take into account international best practices on privacy. And then afterwards, we went to the second plenary, which was again ably facilitated by Mrs. Tope Ogundipe of Paradigm Initiative of Nigeria, one of the sponsors of this event. In that panel, we have Barbara Imayo, we have Enrico Calandro, we have Chris Sibbons, we have Engineer Abubakar Maina, who is the head Cybersecurity Unit, NCC. We have Barrister Chukere Iziogu and Mrs. Chioma. And some of the key recommendations from that discussion is, number one, the need to have a proper oversight on activities of government seeking to access data of private citizens for law enforcement purposes, of course, to prevent abuse. Number two is to determine boundaries of jurisprudence. Indeed, Ms. Chioma was quite emphatic on the need for us to push this boundary. It was also suggested that there should be a multi-stakeholder approach in order to enforce compliance even with data protection regulation. And finally, the panel submitted that there is need for awareness, advocacy, and technical support. And not only that, that this should be elevated even to the level of the AU Convention. And finally, for the day, we had a breakout section. We were divided into two groups, one on data protection, and the other on capacity building with respect to data protection. In the first group on data and security, addressing the gaps in the narrative, they came up with these recommendations. Number one, that individual citizens and legislative arm of government need to be more aware of the ways in which data protection issues affect them through a concrete communication strategy. And I think a lot of emphasis was laid on that, on communicating some of the outcomes of this seminar, even to the relevant stakeholder. There are also other recommendations. One of them, again, is that states should have to report on levels of human rights compliance. This is going to be compiled, in any case, to a report. Now, for the group two, talking about strengthening knowledge-based capacity on data privacy and security, there was also need by that group, it was also clearly stated the need for us at this very onset to begin to build capacity. Various methodologies were suggested, were reviewed, but what is important from that group is everybody agreed on the need and the very fundamental importance to begin to build capacity at every level, even from the very primary level of education up to tertiary. Finally, we had a word, and I think that's by Mrs. Titi Akisomi, which I also think every one of us should internalize, and that is privacy issues are human rights issues. Good morning. Wishing us a very fruitful session today. Have a great day.
Thank you, Dr. Oladisomi, for that insightful recap. Next, I'll be welcoming Nina from Web Foundation. She's going to be making a presentation on data protection report. Can we welcome Nina to the stage, please? We can do better. Can we put our hands together?
Good morning once again, everyone. It's 9:36 now, and I was supposed to be speaking for 45 minutes or 1 hour, but I think I'm going to keep it short. My duty is to inform us about the reasons why we engaged one of the eminent Nigerians to carry on a research on personal data protection in Nigeria. For those of us who were around yesterday who watched the film on the origin of the web Foundation was built on a vision of interconnectedness, on a vision of a free, open, and accessible web. And over the 25 years that the web has been functional and been useful to the millions of people around the globe, we have also come to notice that threats are arising. In one of the studies that we did, I think with Paradigm Initiative as well, on women rights online, one of the reasons why people are afraid to come online, it's the security issue. If you come online and something bad happens, you have that trauma. So there are people who are suffering from digital trauma, and one person was testifying yesterday. So one of the things that is very important for the Web Foundation is to maintain security and safety online. And that is why the protection of personal data is very important to the Web Foundation. So the question is, why Nigeria? It was early this year that we were invited by the Director General of the Data Commission in Ghana to participate in an African dialogue. And I took the message back to my organization and said, this is something that is very important. If Africa is the emerging market for digital world, then we need to make sure that Africans are safe. And we need to begin to understand how to make that happen. And they agreed with me and said, and the question is, where do we start? And that answers the question of why Nigeria. Because if I use the Voice in BBC, it's Africa's most populous nation, that kind of a thing. Nigeria is a very critical country in Africa's economy, in Africa's social, political, and digital economy. It's very important that we understand what happens in Nigeria. But then it is only using Nigeria as a point of departure. Try to understand what else is happening, where else, how, and how do we go from here. And that also explains the reason for my presence in this place. Apart from eating Nigerian food and catching up on carbs, actually personal data protection is one reason why I came. So once again, the vision of the Web Foundation is what motivated this work. The strength of Nigeria and its particular position in Africa is what motivates the study. But overall, it is that final vision of it being for everyone. Today, the UN is talking about leaving no one behind, but we are dreaming of a technology platform, the web, that will be available, accessible. There are some other nice jazzy words like permissionless. When you don't have to write, dear sir, I hereby apply to go online. You know, anyone who's got data can connect online. Anyone can bring their part online. And before we listen to the senior partner or senior advisor, or the barrister who did the study, I would like to leave with us that same thought that Tim Berners-Lee left with us in the video yesterday. If we spend so much of our time online, if we spend so much of our resources online, if we are building our businesses online, if we are building an academic network online, if we spend so much of our time online, we should be able to spend a portion of that time to defend the internet. And I think that also explains why we are here. This study was done across Nigeria in many ways. I think the researcher himself has been around. His name is Chukwunyere Izuogu, and he'll be coming right after me. He's not just a legal fellow, he's also, I think, something called the bearded gang. So when you see a tall, handsome man with a beard, that will be him. Thank you very much. No.
Okay. So on a lighter note, a light-skinned, tall, bearded gentleman. Okay, so without taking too much of your time, I would like to invite the light-skinned, intelligent, bearded man with name Barrister Shooks to the stage to present the keynote address on personal data protection in Nigeria.
Good morning, all. Nina, thank you so much for honoring me this morning. I didn't realize I'm such a tall guy. But thank you so much. Yes, my name is Chukwunyere Izuogu. I'm a lawyer, I'm an IT lawyer. I work with Stream Soas and Con in Abuja. And I was the person that carried out the research on behalf of Web Foundation. Thank you very much for having me here. So we'll start now. I've done some slides, and I'm just going to run this through very, very sharply, as we say in Nigeria. So first things first, I have to give a background into the research. The study was based on to do a comprehensive review and analysis of what the data protection landscape looks like in Nigeria. The study was supposed to identify data protection rules, regulations, or any kind of initiative that actually touch on aspects of data protection in Nigeria. Then the study was also to identify the main data protection risks in Nigeria, and lastly, to recommend policy options for reforming the data protection ecosystem in Nigeria and for follow-up actions. Now, we'll proceed firstly with this assumption, statement of facts in Nigeria. Nigeria, as it is right now, has no data protection statute of general application. That is a statement of accurate fact. Now, but there exists in Nigeria Section 37 of the Constitution that actually guarantees the right to privacy, for all Nigerians, and it's actually limited to only Nigerians. And if you're not a Nigerian, unfortunately, you wouldn't come within the scope of this particular provision. Then there are other sector-specific rules, regulations, guidelines, policy that actually touch on different aspects of data protection as it is in Nigeria, but they are not so much comprehensive to the extent that we can actually call them a robust framework for data protection. Now, firstly, we ask this question: what is personal data? While I'm talking here, sometimes I would use the word personal information instead of personal data, so don't get confused. They mean the same thing. It's not defined right now. Personal information is not defined right now in Nigeria because actually, really, we don't have any statutes, that actually give some statutory interpretation to that. And we also don't have any, as a lawyer, my background in law, there's actually no legal opinion or judicial opinion that actually gives an interpretation of what personal information means in Nigeria. But in other countries, in other jurisdictions, I like the EU framework for data protection, which is recently the GDPR, which would soon become law in 2018. And I'll take you back again. And I'll be referring to it here because that was my standard of accessing the adequacy of data protection initiatives in Nigeria. Under the EU data protection law, personal data is defined as any information relating to an identified or identifiable natural person. Under this definition, there are 4 building blocks. First, we take the first building block, any information. Any information basically means any information. It really doesn't matter how that information is presented. It doesn't matter if it's in a binary form, if it's numerical, if it's pictorial, if it's statistical, if it's alphabetical. As long as however it's presented, it's irrelevant. Relating to means that it's actually about that person. From legal interpretation in the European Union, an information relates to a person if that information refers to the identity, the behavior, or the characteristics of such a person, or can actually be used to make a determination of how that person should be treated or evaluated. I think the first part of this second building block is not so much of a problem because it is self-explanatory. But when we talk about information that can be used to make a determination of how somebody can be treated or evaluated, we look at it. I give you a typical scenario in Nigeria, 2014. There's a credit registry act in Nigeria. The information contained with credit bureau, as it is right now, may not be typically classified as personal information. But sometimes when this information is accessed, to make a determination of how somebody, whether somebody should be, is actually credit worthy enough to give that person a loan, then it becomes information that actually relates to that person. That's just a hypothetical example. Then we go to the third building block, an identified or unidentifiable person. An identified person, the first part of this building block, an identified person is somebody whose identity has been established. I'm here now, I'm standing here, like she just described me. My name is Chukwunyere, I'm a barrister, and everybody sees me here. My identity is certain, is established. Identifiability, it's something, it relates to if the identity with reasonable probability can actually be identified. At a particular time, the information may be presented in such a way that, yes, the identity has not been established, but taking into consideration, the circumstances, the resources, then it now becomes possible to piece this information together to such an extent that they're able to identify this person. I give a typical example again. Nena mentioned, our good old friend Nena, she mentioned about taking pictures, putting it on social media. Okay, she does that, she puts my picture and she puts it on social media, for this conference, and it goes viral, and okay, a lot of people see me, and they start sharing the pictures. Really, nobody knows me. Then probably my friend or my wife comes along and maybe a friend of ours shares it, and she says, oh, that's my friend, and she tags me. At that particular time, I was somebody who wasn't identified, but she tags me on Facebook, and she puts my name there. That means I've been identified. Then the information Nina shared is personal information. That's just one example. Then the last building block is a natural person. A natural person basically is somebody who is alive. We're all sitting down here, and everybody's all looking at me. it means that we're all alive. So you fit the definition of a natural person. But in some other cases too, sometimes somebody could actually be dead, but the information itself would also be personal, would come within this last building block. I give you a typical example. I'm not a medical doctor. I don't know if we have a medical doctor here, but I know that there's some diseases, that are actually inherited from parents to child, like hemophilia. Hemophilia is a blood disorder whereby your blood is unable to clot, okay? Now, mother dies, unfortunately, mother suffers from hemophilia, and mother has a child, but she's dead. From her medical records, which is personal, the doctors discover that she died of hemophilia. She bled out, and they know she has a child, a son, and they've been able to piece this information together and know that this hemophilia is actually inherited, is passed on from parents to child. So they're able to understand that, yeah, we should also take a look at this particular, the child, and then we look into this case. And we see that this from a person who is not a living person, the information has been able to result in tracing the child who is a living person, and they've been able to piece it together. So that's just a typical scenario in which a natural person or somebody who is not alive, an application could be used to somebody who is alive. Now we'll go to the next slide. I hope I'm not talking too fast. Okay, thank you. I'll say that's enough. So typical examples of personal data. We have your personal name, you have a facial photograph, you have biometric information. For biometric information, this information are actually sensitive information. They actually categorize as sensitive information, and they require a stricter level of privacy control to more than the average, typical, ordinary types of personal information. Then we have, within the context of telecommunications, we have your IP address, we have your GPS positioning, then we have your sexual orientation. These are actually also sensitive information as well. Religious beliefs too as well, personal information, and your bank account statement. Those are typical examples of personal data in Nigeria. Then we'll be looking at the personal data ecosystem in Nigeria and the people who actually interact in that system. We have within the actors in this ecosystem, the personal data ecosystem, the typical scenario, what it looks like. There are actually 4 actors. Yeah, 4 actors. We'll start with the first one. The first one is the data subject. The data subject is actually the person whose personal information is collected. I mean, all of us here, we're all data subjects, So we provide our own personal information to people who process it. Then we have the data controllers. Now, the data controllers are the individuals or organizations that determine the purpose and means for processing the personal data. I give a typical example here. Thank God we have somebody representing NCC from here, so I'm sure you can relate with that. We have the SIM card registration database in Nigeria, whereby users of mobile phones, GSM, are actually mandated by law to actually register their input, their personal information, such as DNA, their names, and facial photographs into the SIM card registration database. For that purpose, NCC, which is a telecommunications regulator, is actually the data processor. That's a typical scenario in Nigeria. Data controller, let me not get you guys mixed up. The data controller. Then we have the data processors. These are the individuals who also process the personal data on behalf of the data controller. Still on my last example with NCC. NCC is the data controller. NCC actually determines the purpose for which this information is used. But we have some other individuals, like if I'm correct, sir, I think these guys are called, according to the SIM card registration regulation, these individuals are called the independent registration agents, who are actually the ones that actually collect, process the personal information. These are the organizations whereby people owning GSM, mobile phones in Nigeria actually go to them, and you input your information with them. So these are the data processors. Then we have the third parties. The third parties are actually individuals who receive personal data from either data controller or the data processor. I still standing on the NCC example. The SIM card registration database was actually created so that there could be some credible database whereby law enforcement agents could actually access, because a whole lot of crimes were committed in Nigeria as at then through phones. You know, individuals will kidnap somebody and they will call the family, the family of the victim, requesting for ransom. Because of the anonymity offered by GSM phones at that time, the law enforcement agents could actually were not able to identify the individuals, the suspects. So now, for this same example, the third parties would actually be law enforcement agents or organizations which actually go to NCC and make a request and say, okay, through this line, through this particular number, we suspect a crime has been committed. We need access so that we go cross-reference the database and find out the identity, the person who owns this particular line. So for that purpose, law enforcement agents would be third parties. Then we look at the interaction, a typical interaction within the data protection ecosystem. Now, like I just explained, the interaction, data subjects, you and I, we provide our personal data to the data controller. I gave you an example of NCC. Okay. Let me give it another example, the BVN. You know, sorry for those of us who are not Nigerians. I'm a Nigerian, so I try to relate with what exactly is happening in Nigeria. So we have something we call the BVN, the bank verification number. This is actually something that is being instituted by the Central Bank of Nigeria, whereby people having bank accounts are actually required to actually input their biometrics, DNA fingerprints, and pictures and name into a database. You know, till today I don't know why that is, but it's a laudable project anyways. So in that scenario, the data subject provides personal data to the data controller. Then we have an example of another interaction. It's the data controller who is actually in custody of personal information now provides such personal data to the data processor. Then we have the data subject provides personal data to the data processor for processing on behalf of the data controller. So a typical example would be the NCC scenario I gave. I provide my information to the guys, independent registration agents, who are actually doing it on the instruction of NCC. Then data controller provides an example of another interaction, a typical interaction within the data protection ecosystem in Nigeria is the data controller provides data subjects upon request, provides the data subject, sorry, I think there's a typo here, it provides personal information to the data subject upon request made by the data subject. I mean, this would be in the context of the rights of the data subject. Sometimes a data subject would want to have access to his own personal information. We want to see if it's accurate, we want to see if it's up to date, and sometimes we want to express our rights to be forgotten. So you can actually ask the data subject, the data controller, and say, yes, I want to have access to my personal information. So this describes this scenario here. Then the data processor provides personal data to the data subject as directed by the data controller. I'm sure that's very self-explanatory. Then data controller provides personal data to third party, you know, within the context of cross-border transfer of personal information or upon request by law enforcement agents. Then now this is what is personal data protection. Now, personal data protection is actually related to the right to privacy. A whole lot of people, a whole lot of us yesterday were talking about privacy or human rights of privacy, you know, constitutional rights to be protected, for your private life to be protected, you know, but it's just, it relates to personal data protection. Now, basically what this means is that from a privacy perspective, it means that it's right to be left alone, free from disturbance, and to have your private affairs free from intrusion. Now, but personal data protection is the legal mechanisms that ensures privacy. Personal data protection is the regulatory framework that sets out the rules that guides the collection, retention, protection, use, storage, disclosure, and transfer of personal data. Basically, it's a set of rules that actually guide the processing of personal information. That's what personal data protection is all about. Now, we have examples of data protection frameworks. We have the OEC guidelines governing the protection of privacy and trans-border flow of personal data. This was recently amended, 2013. It's an international standard. Oh, sorry, I keep taking this forward. Underdeveloped countries and every other person to build a framework for data protection within on a national basis. Then we have the African Union Convention on Cybersecurity and Personal Data Protection, 2014. This is an international convention at the African level. You know, a whole lot of countries, I have no details now, but a whole lot of the African countries, including Nigeria, have actually ratified this. Then we have the ECOWAS Data Protection Act of 2013. This is also at the ECOWAS regional level. I think most of the member states of ECOWAS have actually ratified this, including Nigeria. Then, thank God we have this, I'm sure we have a South African here. You're from South Africa. So we have Protection of Personal Information Act 2013, that's South Africa. We have a Data Protection Act of 2012 in Ghana. Madam. Then we have the General Protection Regulations. This is European Union wide. You know, these are just typical examples of data protection frameworks at the international level and the national level. Then we'll be talking about the main elements of a data protection framework. You know, most very good data protection frameworks have commonalities, in the sense that they have some elements, key elements, that is common amongst all of them. You know, I think these main commonalities were actually derived from the fair information practices that originated in the United States. I mean, long time ago, I think 1970 something, you know, and it was built upon by different organizations, both at the national level and at the international level. Now, as of now, there is a consensus, you know, that this is what a typical data protection framework should look like. It must have these particular principles. I think there are 8 principles here. They've been listed out, you know, and we start with the first one: fair and lawful processing. What this typically means is that there must be a legal basis for processing personal information. The legal basis could actually come from the provision of law, which actually spells out that personal information will be processed in accordance with this blah 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 provision of the law. You know, it would also come from consent. You know, consent, once a data subject gives his consent for his personal information to be processed, then that actually satisfies the fair and lawful processing. Then there would also be legitimate interest, and something I like to say, done in public interest. Basically, there's no hard and fast rule about defining what public interest is, you know, but something that is done that satisfies some sort of public interest purpose. Then we have purpose specification. Purpose specification means that personal information must be collected for a particular purpose, and that purpose must be clearly stated to the data subject at the point of collecting personal information. So personal information collected for one purpose would make it illegal for that information to be used for a different purpose. A typical example in Nigeria would be the INEC voters registration database. We all put our information, personal information, into this database, but why we put this information there is to authenticate us, to authenticate voters at the point of voting during elections. Now, that's the whole idea. That's why the personal information is collected and stored in this INEC voters registration database. Now, if that personal information were used for a different purpose entirely, it means that it would be illegal. I mean, according to this particular element, it would be illegal. Then we have relevance or data minimization. It means that personal information collected should be relevant to the purpose for which it was collected. I mean, if it just requires me to just submit only my names and my facial photographs, I mean, there's no point in collecting my fingerprints, strands of my hair, which make up my DNA, and other kind of identifiers. I mean, that would be illegal under this particular element. Then we have accurate. It means that those in custody of personal information must actually take steps to ensure that the information contained, held with them, is actually accurate. And if it's not accurate, they should try and make it accurate. Then we have retention. It means that information should be retained for no longer than is necessary to actually achieve the purpose for which that information was collected. It means that once this information, once purpose specification has been met, then the information should be discarded. Then we have data subject rights. Now, what this means is that as a data subject, I have a right to meet those who hold my personal information and tell them that I want to see what type of information you hold about me. I know Google does that. You can actually make a request to them and they'll give you all your footprints online. They'll send it to you as a report. And that's what basically this means. And there is a new dynamic to this. Recently not so recent, in Europe, there's a new right that's related to the data subject rights that actually is the right to be forgotten. It means that if I no longer want you to hold my information, I have the right to request that my information with you should be discarded. Then data security. It means that, what this means is that those in charge of personal information should actually adopt security protocols that ensures the confidentiality, integrity, and the availability of this personal information and the systems used to process or hold this information. Sir from NCC, you're a cybersecurity expert. I'm sure you would agree with me. There's some cybersecurity aspects to data protection. Then we have accountability, which is the last principle of data protection. Basically, what it means is that those in charge of personal information, those in custody of personal information, should actually adopt internal processes to ensure that the 7 above main elements are actually complied with. Under the GDPR, which is coming into force in 2018, there is actually a rule. It actually obligates those data processors and data controllers to actually have a data protection officer. Now, the role of this data protection officer is to ensure that, to make these organizations accountable to every other principles of data protection. They must adopt processes that actually ensures compliance with data protection obligations, conduct data protection risk assessments, and to take steps to mitigate risk from a breach of data protection. Sorry, a breach of security. So that's what the accountability is all about. So these 8 are the main elements of a very good data protection framework. Now, let's come back to Nigeria. I just decided to give some substance to what we'll be talking about right now. Now, like I earlier said, the study was to identify data protection related initiatives in Nigeria. What I did was to go through basically almost all the laws of Nigeria, the existing regulations, and every other thing that has the force of law to actually identify frameworks that actually touch on aspects of data protection. I'm not, if somebody had, I don't know if the final copy of my study has actually been shared, but if it isn't, I'm sure at a later date, it will be shared to those that drop their email addresses. But for this presentation, I actually picked out some of them. I highlighted some of these frameworks. And we'll start with the Constitution. The Constitution, Section 37, actually provides the privacy of citizens, their homes, correspondence, telephone conversation, telegraphic communication is hereby guaranteed and protected. This provision itself, it's very much narrow in its application because it only relates to Nigeria. It means Professor Chris Seaborns is not protected by this information, by this provision. So because he's not a Nigerian, and it means every other non-Nigeria here is also not protected by this provision. It only applies to Nigeria. Then another example, I looked at the Credit Reporting Act of 2017. This is a very recent act that was signed into law by the president this year. It actually says, it actually touches on different aspects of data protection. It says now A credit bureau shall maintain credit information for not less than 6 years from the date on which such credit information was provided to it, or if later on the date on which it last provided such information to a credit information user. Basically, this touches on the data protection principle of retention. It says that this information should not be kept for longer than 6 years. Then we look at the Cybercrime Act. I looked at the Cybercrime Act, and Section 38(4) says any data retained, processed, or retrieved by service provider is a mobile network operator, at the request of any law enforcement agency under this Act shall not be utilized except for legitimate purpose as may be provided under this Act or other legislation regulated or by an order of a court of competent jurisdiction. Basically, this is consistent with it's consistent with the principle, the data protection principle of fair and lawful processing, this particular provision. Then I also looked at the NCC, the registration of telephone subscriber regulation, which was it's an administrative rule regulation enacted by NCC. I looked at regulation 9.4, which says licensees, independent registration agents, subscriber registration solution providers, blah, 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 shall take all reasonable precautions in accordance with international practices to preserve the integrity and prevent any corruption, loss, or unauthorized disclosure of subscriber information. I stopped there. Basically, what this means is this particular provision is consistent with the security principle of data protection. Then examples of types of personal data collected in Nigeria. Offline, I categorize these as both offline and online. Offline, we have names being collected by almost everybody in Nigeria. You go to schools, your HMO collects your names. In Abuja, you want to go into a public building, the security men collect your names, your telephone numbers, and also whatnot. Fingerprints is being collected by INEC. For the INEC voters registration. NCC does the same. And some buildings in Victoria Island. Are you serious? Okay. Oh, beautiful. So, so that's a typical example in Lagos. Then we have residential address, which is being collected. It's also personal information in the sense that, somebody could actually, it's not personal information in the sense that it would lead to it actually establishes the identity of a person. But you could actually trace a person residential information and go to the house and find out that such person, Nina, probably stays in that house. Then we have telephone number. Then we have health information. Then online we have your names. Some platforms actually collect your names. Platforms like Google, Facebook, social media platforms, email addresses. These same platforms do. A whole lot of platforms collect IP addresses. Then ISPs actually collect clickstream data, which enables them to see what you are doing at a particular time. What you actually, what websites you visit. Then some online platforms do actually collect telephone numbers, then location information, and some platforms actually collect your sexual preferences. I'll get into that later. Then some organizations that collect personal data in Nigeria. Offline, we have the NIMC. The NIMC is actually an organization, the National Identity Management Organization. This organization is actually empowered, taxed by law to actually register every person living in Nigeria. So for you to be registered in Nigeria, you must have a national identity number, and they collect personal information from you. We talked about INEC, which is the Electoral Commission, the NIS, which is the immigration, the Nigerian Immigration Services, they actually collect personal information. The VIO, which is the vehicle, for those of us that are Nigerians are very familiar with these guys, they actually collect your personal information. Then banks and financial institutions also collect personal information. Hospitals, HMOs also collect personal information. Your health record is actually personal information. Then online, we have Google. What I did was, I forget the name of this website. At the point in time I was conducting this study, on a particular day, I had to look at, there's a particular website that kind of measures websites in different countries that actually have the most visitors. On a particular day, Alexa, thank you, ma'am, Alexa. So for that particular day, during the course of this study, I actually got out, I think about 20 or 30, it's reflected in my study, of platforms that had the most visitors in Nigeria. You know, I chose about 20 or 30 of them at random. You know, we have Google there, and they collect personal information. We have YouTube, we have Facebook, we have Twitter, we have X videos. X videos is a porn sharing website. They actually collect your sexual preferences. Sorry, ma'am. Yeah, I had to confirm. Yeah, we have Truecaller. We have Truecaller. Truecaller, everybody knows Truecaller. You know, also collect personal information. Then we have ISPs. ISPs collect your personal information, clickstream data, and the rest of it. Then, yes, ma'am. Yes, sir. Oh, okay. It's fine. Okay, and there's a part of my study that is not reflected in this slide. You know, I didn't want to get into much details about that, but I'll just give you a bird's eye view of what that part talks about. I actually, during the course of the study, I actually sent out questionnaires to, I think, about 102 respondents that they kind of like wanted to gauge their responses to data protection issues in Nigeria. You know, different, I can't remember the exact questions that were asked, you know, and they responded yes or no, and sometimes it was an open-ended question whereby they had to give their own thoughts. But in terms of the main data protection risk, from the perspective of Nigerians, I mean, from the perspective of those respondents, you know, I think the most pressing of them was incidents of security, you know, security and use that incompatible use of personal information. So that's just a bird's eye, but this whole thing is reflected in a particular chapter in my study. You know, so we now jump to data protection risk in Nigeria. I categorize this as both risk offline and risk online. Offline risk, we have incompatibility of purpose. What this means is that if because of there is an absence of data protection law in Nigeria, you know, we find out that those people that actually have access to our personal information actually misuses. You know, and one of the risks I was, during the study, I actually discovered is that most times, offline, in the offline scenario, you find out that information that is actually meant for, that was actually collected for one purpose, is actually used for a different purpose. I give a typical example. And recently, there's a whole case in Nigeria. Everybody heard about this guy, Maina, you know. Maina, okay, well, I'll get into that. PNR is a passenger name record. This is an example. The information is actually collected by airline and aviation operators to maybe schedule your flights, taxi services from the airport and stuff. That's why this information is actually collected. You know, but in Nigeria here, there's actually a report from this, I don't know if it's the Department of Homeland Security or State Department, that actually says this information. The Nigerian Immigration Service and the SS, which is like our CIA or FBI, they actually have access to this information to actually monitor those that they perceive as security risk. You know, why I mentioned Maina recently was, is alleged to be a fugitive. He was indicted for some crime. He wasn't in Nigeria. He came back to Nigeria, and a whole lot of people are asking questions. And I was reading yesterday that the head of our immigration service actually said that he was directed to remove this individual from the watch list of the security agents in Nigeria. He was directed by our intelligence agency, you know. So that's one purpose where this PNR comes into play. You know, maybe they were monitoring if he would come into Nigeria, but apparently they said, okay, no, he's not. Anytime he comes into Nigeria, just give him some breather. He's all good with the government now. Then we have another risk. We have data subjects have no rights in relation to their personal data. We talked about the main elements of a data protection law. We talked about the data protection right. The rights of the data subjects to actually have access to their personal information. You know, in Nigeria, yeah, I mean, has anybody actually gone to NCC to ask if I want to see my information, the information you have with you in the SIM card registration database, or INEC, or passport office, you know? mean, nobody has done that. I haven't done that because to a certain extent, we have no such rights, you know. So, and a typical scenario, I'm sure we can all relate to it. I regularly go, because I'm getting old, I regularly go to the hospital. You know, when you become old, you know, a lot of things are happening to you medically. So, but when I see my medical file, I want to have a look at it, and the doctors tell me I have no rights to. I mean, this is my file, this is my personal information, but they don't want me to look at it. And sometimes it's a tug of war between me and medical officers, and I say, well, what the hell? This is Nigeria, obviously, probably because we have no data protection statute in Nigeria. Then in the context of online, we have lack of adequate consent. Now, consent is it flows from fair and lawful processing. You know, if somebody gives his consent for his personal information to be used, you know, then it satisfied the standard of fair and lawful processing. You know, and I also understand that consent must be informed. Basically, what this means is that at the point of requesting for my consent to use my personal information, you must make available to me the necessary information on which my decision of whether or not to give you my personal information would be based. You know, consent must also be freely given in the sense that there mustn't be any form of coercion. You know, we have some platforms online whereby they tell you that access to them is dependent on you giving them the right to be tracked. And if you can't access, and if you don't say, no, I choose not to be tracked, I don't want you putting cookies in my system, and they tell you, oh, sorry, you can access this website. You know, in that particular case, consent has not been freely given. Even if it were, then consent must be specific. Specific means, you know, if I'm giving you information, if I'm giving my personal information for a particular purpose, you know, if it must be used for that cause, and on which my consent must be based, it means that the consent itself must be granular. You know, but online platforms these days, you know, especially some apps, you know, they ask you, can I access your contacts? You give them your contacts, they access your contacts, and they're looking at every other thing in your phone. You know, I think there's a recent case of a case in the United States whereby a Torchlight, an app that is a Torchlight, you know, had so much access to personal information, and the FTC actually took them to court. You know, so there is, you know, even if we give consent, we need to know why we are giving the consent. We need to know what the information is being used for. And the consent itself is not just a blanket consent for every other purpose. It must be restricted to a specific purpose. So that's one of the risks I was able to identify within the context of online platforms. Then we have lack of transparency in the processing of personal data. Now, there is I like this statement by somebody some years back. He says, the data subject is in a fog of data ignorance. Basically, I mean, a whole lot of us don't know how our information is being used, what our information is being used for, how much information, I mean, a platform has about us. You know, so it's, I mean, it's typical in Nigeria, you know, because obviously, we have no data protection statute of general application. So, I mean, a lot of data controllers, data processors can actually process so much information, you know, and just keep you in the dark about how this information is used. Then we have lack of security and the risk of a personal data breach. In Nigeria, except in very few typical few instances, you know, provided under the law, under statute, there is no positive obligation on online platforms to actually adopt security protocols that would actually ensure, safeguard the confidentiality, integrity, and availability of personal information or systems used to process this information, because really there is no obligation. So because of that, the data subjects in Nigeria are actually exposed to the risk of a data breach. What this means is that your information with somebody, INEC database, NCC database, can actually be hacked, and somebody has access to it. You know, and I mean, you're not entitled to any form of legal remedies. You know, then incompatibility of purpose, I've actually talked about this. You know, for the online platform is actually very much huge in this era of big data analytics and Internet of Things, whereby platforms collect as much information as they collect. So there is a thin line between where lawful processing stops and illegal processing continues. So incompatibility of purpose, that exemplifies it. Then now there is a risk to children in Nigeria. You know, my son, he actually uses the internet. You know, he goes to YouTube, he watches cartoons and stuff. You know, but sometimes too, there's also the risk, because when they go to some platforms that are actually designed for kids, they are collecting information from them, not from them directly, but through my device. You know, sometimes too, we should, you know, children are exposed to so much risk because it could be profiled online. So this was one of the risks identified in Nigeria within the context of online platforms. Then I also made policy recommendations. You know, I made policy recommendations. I think there were 1, 2, 3, 4, 5, 6 of them. Now I started with policy recommendation is actually, despite the absence of a data protection framework in Nigeria, what can be done to mitigate data protection risk in Nigeria? Some sort of measures that can actually plug this gap in terms of data protection risk in Nigeria to ensure that the rights of the data subjects, it's protected. These rights are protected. So, the best measure the study recommended is to enact, under the legislative measure, is to enact a data protection statute. You enact a very robust data protection statute that contains the main elements of a data protection statute. From what we talked about at the security, lawful processing, those principles of data protection, it contains them. Then it's fine. Nigeria is good then, in terms of data protection. Then we could also amend the National Identity Management Commission Act. And we're talking about the NIMC. The NIMC is actually the lead organization in Nigeria that is empowered to collect, to actually create database for everybody in Nigeria. So you can actually amend that act. You could actually amend that act to empower the NIMC to act as a DPA, Data Protection Authority, you know, and to actually amend it also to bring the scope of their activity, the scope of the authority to capture both public sector participants and private sector participants. Then we enact a Child Online Protection Act that would actually set standards for online platforms that collect personal information from children. Then in terms of the non-legislative measure, we, under the NIMC Act, NIMC is actually authorized under its enabling act by Section 31B to make regulations for the collection and processing of personal data. Is there anybody from NIMC here? So we could actually push for NIMC to actually exercise that power. So, but it's limiting because the scope of NIMC power only extends to public organizations that actually hold information, personal information. Then we have judicial measure. This is, for those of us that are lawyers here, this is some, what's it called? Is it legal philosophy or philosophy of law? One of them, I probably forgot that since my undergraduate days. You know, we actually encourage the judicial officers, you know, the law courts, presiding officers at the courts of records in courts to actually engage in some form of judicial activism. Judicial activism means that, you know, because of your personal doctrine, you can actually make a decision that is consistent with that person, those doctrines. So what this study is calling for is to expand the scope of Section 37 of the Constitution, which we talked about, to actually include the protection of personal information. You know, there's a recent judgment in Nigeria, which is actually a step in the right direction. You know, a lawyer, Barrister Eneye, actually took an MNO to court, MTN to court, on the basis of this Section 37. They went to court. He said, because this MTN MNO had access to his personal information, that is his telephone number, shared it with third parties, and these third parties were actually shooting him with unsolicited messages. He went to court. He pressed for his rights on the basis of Section 37 of the Constitution. He was awarded 10 million naira at the first court. MTN appealed. MTN lost at the Court of Appeal, and the judgment as it is still stands. And this is a very novel interpretation of Section 37 coming from the bench. So we're calling for more of that So there should be some flexibility in how they interpret Section 37 of the Constitution. Then we have enforcement measures. In the enforcement measure, we're calling on the Human Rights Commission in Nigeria. The Human Rights Commission is actually authorized by law to actually investigate cases of human rights. Now, what we are calling for is we are calling for the human rights should actually beam its searchlight on issues of data protection, because this to me, in my opinion, and I will strongly argue this, that issues of data protection is actually a substantive legal rights that derives from human rights. So on that basis, since you're actually empowered by law to enforce human rights, to investigate human rights breaches, you can actually look into issues of personal data protection in Nigeria. Then we'll talk about the Consumer Protection Council. The Consumer Protection Council in Nigeria is also authorized by Section 31 to actually investigate cases of unscrupulous exploitation of consumer. Now, I'm borrowing from the US experience. The FCT in the United States is actually the lead consumer protection agency in Nigeria, and despite the absence of a comprehensive data protection law in America, the FTC has successfully enforced cases of breaches of personal data. You know, they've gone to court, some organizations have taken them to court, and they succeeded. You know, the judgment was given in their favor. And we can actually borrow from that in Nigeria. The CPC actually has broad powers under its Section 2(1) function to look into this. And basically, I'm arguing that this unscrupulous exploitation of consumers contemplated by this section, this particular provision, also includes matters of data protection. Well, this is a novel way of interpreting this particular provision, but you know, it's possible that, yeah, it could swing in my way. I would strongly argue for this in court. Then we're also calling on sector regulators and NIMC and sector regulators to actually mandate data protection by design, which ensures that platforms or technologies that are being designed should actually, from their conception stages, should actually have the default position of protecting personal information. Don't collect so much information. That should be from the conception stage. Then we're actually also mandating that this sector-specific regulators should actually mandate transparency obligations while on data controllers or people who collect personal information. Then on the executive measure, this study is actually calling on the federal government to actually make some sort of directive that every other, you know, like I just told you now, a whole lot of agencies in Nigeria collect personal information. We have the INEC database, we have the NCC database, we have the VIO collecting, we have the Immigration Service collecting, we have this, we have a whole lot of them, at least 610 or so in Nigeria, you know, and this creates duplication of efforts for the data subject and resources on the part of the government, because this information is the same. You put the same information you put here. Why don't we just harmonize just a single database? You should be in the custody of the NIMC, and everybody, I mean, under pursuant to a lawful order, a legal provision, they have access to this information. You know, so the BVN2 database is all there, scattered everywhere. You know, so just make it uniform so that we don't, I don't register multiple places, and everybody that needs access to this information just come to a centralized database. It saves resources, and I think the government made a statement about 2-3 months back that they're looking into this. You know, because I had a personal experience. I tried to get my national identity number from the NIMC recently, 3-4 weeks back, and I was asked for my BVN number. And I gave them my number, and it was actually inputted in the system, and my picture comes up, and I'm asking, and they tell me they've already started the process of harmonization. The systems are now interoperable, and I think that's a good step in the right direction for the Nigerian government. Then lastly, we're calling on social measures. The social measures are for civil society organizations who are actually engaged in massive awareness campaign of the risks of data protection, the need to have a data protection legislation in Nigeria, you know, and for the adoption of privacy-enhancing technologies in Nigeria, and sometimes to actually engage in public interest litigation to actually protect personal information. I know in the United States, the Electronic Frontier Foundation, it sues the US government on different angles, takes them to court, when they feel that personal information is infringed upon. They engage in public interest litigation. So what I'm calling for is all manner of CSOs. The Web Foundation is here, and all other civil society organization. You can do this and drive the awareness and finally to also lobby for a data protection framework. And I think this is the part where I come to the end of this session, and I thank you all for listening, and I go sit down now. Thank you. Thank you.
Thank you very much, Chicks. I kept looking. I went behind, I looked from behind, I went to the side, I looked from the side. It looked as if it's something of interest to you. Anyway, it's 10:35 now. I'm hoping we'll keep to time today. We're going to break for a short drink, a bio break, drink some, pee some out, come back. But when we come back, we're supposed to have a panel. I'm going to modify that panel because, as I said, I was looking around and some people were more possessed by the Holy Spirit of data protection than some were. And I noticed Teki was like, those two there were deep into it. So I'm going to ask for your personal feedback after this. If you are listed on the panel, don't stress. We'll still come back to you. Barbara is on that panel, and Tokwe from civil society. But I think that this is one panel where you should say something if it has to be said, because it's not just for Nigeria. Like I said in the beginning, it's for all of us. So, Chooks, don't go too far, because we have issues. Yeah, he was enjoying it, but we still have questions. So we're going to have a discussion among us when we come back, and our panelists are going to serve as resource persons. Now, we have a few minutes for me to tell you some behind-the-scenes stories. Are they streaming us live? Oh my goodness. Okay, I have to think twice now, eh? Okay, so we commissioned the study, and then this gentleman shows up, he applies for it, we do the interview and all of those things. And by the way, is Michael Awoleye here? Mike was one of those who applied for the study out of passion, and he's here. So get ready to give us what you think, because he was one of those who also did the peer review for the draft. But the thing is, the first draft of the report had about 80 pages. That's the side story. And people are like, who is this person who did an 80-page report in 2 weeks? So then we knew we were dealing with a freak. Either he was a freak, he was crazy, or he was just simply passionate. You see, and then, so the work was no longer on getting the content, but on knowing which part of it to cut. But I just want to give him homage, because it is due him. He put in more than intellectual capacity in the work. And in the middle of it, a child was born, a son was born, and maybe, who knows, what NIMC will give to that boy. But it has been a very interesting journey doing this. And like I said, it's not just being done for Nigeria, it's to kick off and see where else this needs to be done. I'll be keen to hear people from other countries if the issues raised here resonate with them in their own countries. We want to recognize the presence of Mr. Paul Nwulu of Ford Foundation, who arrived from Lagos this morning. He so much wanted to be part of this. The other side story, if you go to Ford Foundation headquarters in New York, you should visit the ladies' restroom. I haven't had the opportunity to visit the male restroom, but you should go to Ford Foundation and see how they believe in social justice up to the toilets. I just want to put that aside. And as we do these things about human dignity, about human rights, we need to keep it in our forefront. I took that from Teki yesterday, that privacy, no, it was a Titi or Teki, one of those tea ladies, that privacy is a human right. And I think that when you get into private areas, your dignity should be protected. When we come back from the tea break, we are going to go deeper into this. Thank you very much, and bon appétit.